we are very lucky to be joined by Caroline again this morning. And Fran will be coming in this afternoon. So, as with last weekend, my intent is to split the two sessions as we can and run until, say, 12:15, I think, this morning, and then pick up again at 1, which will bring us hopefully to a neat close at 4:30. I'll obviously try and break us as well in between both sessions about halfway through. So I think today we're just going to plough on then with some of the core topics dealing with the companies law. This morning I'm hoping we'll be able to get through corporate capacity, constitution of the company, and the basic administrative type issues that come with the use of directors. And then this afternoon we'll look onto the more litigation-heavy directors' duties and minority protection. So I'm optimistic we'll get through that today. We'll do our best, certainly. But I think just as a starting point, Caroline will, as being the first adjunct here for companies, will just give us a kind of broad overview of companies law and go into.
Okay, morning everyone. So I thought I'd just give you a brief overview, and I'm pretty sure you'll probably all know this, but it's probably not. It's probably worth just running over some of the key issues. We obviously have the 2008 law, which came in 1st of July 2008. All companies that were on the register before then had to re-register, essentially. So you have to make sure that, I doubt that any of this will have happened, but if you may be dealing with a really old company and for some reason that hasn't got itself re-registered or whatever, that in and of itself would be something to think about. All of the because with the 2008 law, we also got the electronic register of companies. There was this massive change from just these paper documents into a system where a lot of things were being sent and filed online. And I think one of the things when you're looking at your company searches and things like that is always to have in the back of your mind, is there any, particularly if you've got an old company, pre-2008, do you think there might be things lurking in potentially hard copy documents that you need one of your clerks to go down and check the file, etc.? Because that's sometimes, we can sometimes find that there might be information that is there that could be helpful. Remember also, though, that the information that was on that had to be filed pre-2008 was in and of itself relatively limited. I mean, think about the information that you have on an annual return. You've got the details of the directors. Obviously, you don't have details of shareholders, but sometimes that old information where you're dealing with an old company can be helpful because it tells you that thing where you had to file things around when you were issuing shares, when there were changes to the capital, etc. You can find information sometimes there. And in fact, I've had a recent example where I've been asked to go back and look at things from the 1980s. And so, we're having to go back for someone there to get the hard copies to just check what was on annual returns and things like that. So it's not out of this world that those are the kinds of questions you may be asked. Just in terms of what I think, we'll come on to it because of the Constitution, but you can sometimes, when you're dealing with a company, you could be dealing with really old articles and memorandum. What you'll find when you've got your really old memorandum is if you've got very detailed old objects clauses, and you need to think about that because you're still having to think about, what the company can do. So that's always something to think about. And if you get the opportunity to amend that kind of stuff, you should take that opportunity and just go for something that's in a much simplified form. Similarly, when you're looking at articles and you have things where, obviously previously when we used to do a share capital reduction, that would be with a special resolution. When we were dealing with dividends, sometimes it would be an ordinary resolution needed to be passed, and you also have to pay out from the profits of the company. we'll move on obviously to the solvency test, and all of those types of provisions we don't need now to worry about. But if they're still in the constitutional documents, you've still got to think about them, because that's the governing, those are the governing provisions. And so you can sometimes have the odd things like powers of attorney having to be executed in a particular way. So there are all those things, and they really are throwbacks to the 94 law, sometimes even older. On your memorandum, you may find that you have to have 7 shareholders. That's a throwback to the really old companies law. And I have seen companies that still have some of those provisions. But even if they've got rid of things, the number of shareholders, they still may have lurking in their articles for a quorum requirement that you've got to have, a higher number of people there, because of they're harking back to the number of shareholders you used to have. So it's all things like that be aware of, because they can just make you have to stop and think about them. If you're thinking about then the company's law, 2008, it obviously brought in some fundamental changes. I think one of the most important was our move away from English companies law, where they've got the capital maintenance rules, and we moved into the solvency test for distribution. So I always think that's a big issue to think about. It obviously also procedurally provided things that you can have all manner of type of company, unlimited companies. I've dealt with one of those in my time. We do see LBGs, limited by guarantee, but often that's you're in charitable status sectors, but also the gym club, that kind of thing. But we do sometimes see those companies being used in a more commercial context. I mean, clearly much more is the company limited by shares, the PCC, sometimes the ICC, but not as much as I think people thought we would necessarily see it. But I'm not in the insurance sector, so people who deal with insurance possibly may see that a little bit more. I think the other thing to think about with this is that it's not just the law. Remember that there are all those regulations that sat behind the law when it was coming in. And when you think about things like distributions, if you think about stuff like financial assistance, remember there are regulations here that you need to be looking at, which are very helpful in being able to interpret what is financial assistance and what may fall outside of it. You'll be aware that there were transition provisions that applied for a number of years, that meant that certain things you didn't really need to start changing your memorandum and articles. But now you would be expecting to see, for example, a statement in your memorandum that says you're not a cell company. So there are things like that I think you could be. I'm sure you'll all have your internal notes that will help you with that type of process in terms of the constitutional documents and the transition to this 2008 law. I think it's been a law that we found has helped us to remain more flexible as a jurisdiction. There are always things that we need to point out to practitioners, particularly in the UK, who are used to their Companies Act. They're obviously very much more used to the distinction between a private and a public company. And of course we can say we don't have that distinction. That can be an interesting question when it comes to some of the procedures around how the takeover code, for example, may apply. Some of the procedures that under English law people are thinking about in terms of where you have to file things with their company's registry in order for actions to actually take effect. And of course, usually we don't have those types of provisions. And I think in particular areas such as a scheme of arrangement, where we've seen an absolute uptick in the context of takeovers of companies in Guernsey over the last few years, the procedure that English lawyers would expect to see is slightly nuanced over here. And what we've done is built up a process with the Guernsey Court of how those the necessary steps are taken for a scheme. So there are all these little areas. Now, in terms of what would be examined, I think what you need to have an obviously an understanding of what's in here. And obviously there are we've just been talking about, there are areas where there are just really procedural steps that need to be taken, processes that need to be that you need to bear in mind, but very practical advice that you would give to your client in order to remind them of that time period and the expectation around when documents need to be filed. So I think you do need to have a handle on that, even if you don't have it necessarily at your fingertips in terms of time periods and stuff, because it's obviously in here. But remember, you're thinking about how you're advising your client and what your procedures need to be, and the things they need to be aware of, so that it fits into, because you're typically talking about structures that have other jurisdictions involved. So they need to be aware of what has to happen here. I think you also, the registry website, if you've ever looked at that, has actually got a lot of really useful information on it. Procedure, they always obviously caveat all of their notes with things like, don't take this as legal advice, and that they're obviously right to do that. But what they've done over the years, I've noticed, is they've put a lot more forms on the registry, which are actually very useful in terms of a number of these procedures where you're doing conversions and things like that. So don't discount that, and I think you should have a look at those and just spend a half an hour just flicking through to see, because oftentimes what you then may get is a client saying to you, well, I've seen this, this, this and this, so this is all I need to do, and then you have to kind of fill in the gaps and go, whoa, before you do that, there is a solvency test issue here, you're going to think about that. So bear those things in mind. But I think one of the important things are, think about the regulations that sit behind this, that they can be quite important. Okay.
Good. Okay. Thank you. Well, Caroline was discussing one of the points that we need to cap up today, dealing with objects clauses and corporate capacity. This goes really hand in hand with one of the other sets of slides that I produced, dealing with the constitution of the company, and I don't think there's any particular need to do them in one order or the other, but given that Caroline's mentioned it, corporate capacity, I guess we can start with. It's really quite brief. Obviously, as we understand, the company is a separate legal person. That means it can do certain things, as we explored yesterday, and as you well know, it can buy property, it can sell property, it can borrow money, it can lend money, so on and so forth. Its ability to do that, though, is dictated by its capacity in law to enter into contracts, to enter into transactions. This was a much more exciting topic, perhaps, pre-1985, when the English courts really struggled with the idea, the concept of corporate capacity. And more so the way in which over time the needs of a company and its objectives might change. Now, as it is, there's in all jurisdictions, I think, through UK and the islands, very simple answer to issues of corporate capacity, which is generally the third party will be protected, the transaction will stand, and it becomes an internal issue for the company to resolve if it wants to take issue with the director who caused the company to enter into the transaction or what have you. So generally speaking, the answer to any question that is going to corporate capacity has a fairly straightforward answer. But I'll just say very briefly a little bit about the history here and the reasons why it presented so many problems to the courts in England and Wales during the 20th century and the latter part of the 19th century. As Caroline mentioned, you would expect in a memo for a company to have its objects clause. a clause detailing the objects, the purpose of the company. And historically, if we go back many hundreds of years, companies were incorporated under statute. They were given a very defined purpose pursuant to that statute, and that followed on then through the use of the objects clause. And in those companies which were being formed in the 19th century and the 20th, early part of the 20th century, those companies had extremely limited, extremely restricted objects clauses that said they were to do a certain thing, to fulfill a certain purpose. In the English courts, took a very restrictive view of what that meant. In Ashbury Carriage, the court here, 1875, recognised that if a company does anything which exceeds its powers, as limited by its objects clause, then that thing, that act, that transaction would be ultra vires. It would exceed the capacity of the company, and as such it would be void. So in Ashbury Carriage, the court looks to the objects clause, they see it, identify it as being a very limited term set out in black and white in here, a memorandum, and they don't leave any room for interpretation of that clause. It says what it says, and that is the limitation on the power of the company to enter into certain acts, contracts, transactions, etc. What followed from there then were many hundreds, I think, of cases where the courts were asked to determine whether or not a particular contract or a particular transaction was enforceable in circumstances where it exceeded the limitation of an objects clause. Read John Beaufort, 1953 here. One example, the company's objects are basically to manufacture costumes and gowns and any incidental purposes thereto. Over time, though, the business diversifies and builds a factory to manufacture veneered panels for furniture making. So this isn't just a minor diversification, this is the construction of a factory to produce these panels. And in order to proceed with that line of business, the company enters into various contracts. A contract with a builder to build the factory, a contract with a supplier of the materials that they would use for the veneers, and a contract with a coal supplier to fuel the factory. Long story short, company is rendered insolvent, and various creditors, including the three I've just mentioned, seek to prove in the insolvency. The liquidator rejects their claims on the basis that all of those contracts went to the business of producing these veneered panels. However, that was beyond the powers of the company. That was beyond the scope of the objects clause, which was simply limited to manufacturing gowns, costumes, and anything incidental thereto. On that basis, the liquidator said each of these contracts, even the construction contract for the factory, they were all ultra vires. The company did not have capacity to enter into them, and as such, going back as far as the principle is established at Ashbury, those contracts were ultra vires and therefore void. The practical effect of that being that if the liquidator was right, each of those creditors would walk away with nothing. They wouldn't be entitled to prove in the liquidation, and they would bear all the losses on the contracts they've entered into. And as a great example of the problems that the objects clause and its interpretation presented, the court agreed with the liquidator. And those creditors recovered nothing in the insolvency on the justification that their contracts were ultra vires and therefore void. One of the issues that meant that the court, again, found it difficult to move away from that very strict interpretation of the objects clause was that at the time, the memo and arts under English law were still subject to the doctrine of constructive notice. So the fact that those documents existed in the public domain, that they could be accessed and retrieved from the registrar of companies, meant that anybody transacting with a company was deemed to have constructive notice of the contents of the memo and the arts. It didn't matter that they hadn't actually gone to the memo and arts themselves and read them to determine that there was some limitation by virtue of the objects clause. They were deemed to have constructive notice, in effect placing the onus on that third party to undertake their due diligence, to obtain a copy of the memo and arts, to satisfy themselves that the company could enter into whatever the relevant transaction was. And none of the creditors that I mentioned in John Beaufort, and there was a section on this in the judgment, none of the creditors in that case had actual knowledge that the various contracts they were entering into were ultra vires. They only were deemed to have had constructive knowledge, and still the court found that it was their loss. They should have undertaken their due diligence, and they failed to do so. There are many other cases that I would tend to go through on an undergraduate course that show the same principle and effect, the combined impact of the very restricted interpretation of objects clauses by the courts and the doctrine of constructive notice, working together to basically mean that over 100 years worth of jurisprudence, the third parties here transacting with the company who was acting ultra vires, it was those third parties that suffered the loss. The decisions in those cases, though, grossly unfair. And so it comes through to the UK's negotiations at its entry into the EC, of which one of the, I thought, specific requirements was that the doctrine of constructive notice be disapplied insofar as its effect on the memo and arts were concerned, to regulise the position across Europe. So it was the doctrine of constructive notice which fell away first. It was disapplied to the memo and arts through the Companies Act. And then, with the 85 and then slightly improved the 2006 Act, the legislature then sought to introduce what we call the saving provisions. And they exist in very similar ways under the 2008 law. Saving provisions which are designed to save, to protect the third party contracting with a company which is acting ultra vires. And it's those provisions which operate in two slightly different ways, which have the effect that I referred to earlier of protecting the third party, so as to mean that the relevant transaction remains valid, enforceable by the third party, such that if any losses are suffered by the company as a consequence of that transaction, it's up to the company to deal with it internally. And so if a particular director has caused the company to enter into that transaction, well, the company needs to take issue with the director to recover its losses. It becomes an internal issue. But insofar as the third party is concerned, the outside world ought to be protected. There are some limitations on that, as I'll explain. The starting point, though, you see here under the Guernsey law, section 113, unless a company's memo specifically limits its objects, the objects of the company will be unrestricted. That's the default position now. So as to avoid all of these issues from the outset, if a company's objects are unrestricted, then there can be no complaint that it's in some way acted ultra vires, that it's in some way exceeded its powers. As Caroline observed, though, this is a fairly recent development, and so you will find, I would have thought in practice, companies that still have limited objects within their memos. It's less common now in the UK in a way, although I imagine that the position is, based on something you just said, probably fairly similar here. You would have to go a very long way back to find a company in the UK with restricted objects clause. Because by the mid-20th century, the common practice in the UK was to draft these objects clauses, which were 4, 5, 6 pages long, and which covered off every single possible transactional thing that you could ever imagine doing with that company. And so you'd have to go a long way before that, probably, to find a company with a very restricted objects clause. So there's not only that, but also they started inserting a very broad clause as a sub-clause which said, and any incidental commercial activity to all of the above. The court's never really got a chance to test that and whether or not it would stand up, because developments overtook through the introduction of the Companies Act, the 85 revision, which had these saving provisions in. But is that right? Generally, you would expect, yeah.
And then there was a period of time before we went through the I'm pretty sure it's 2008 changes, where people started to slim down their objects clauses and try to put really general language in. But when I know this from having, and it must have been the late 90s, early 2000s when I arrived, when this was a bit of a conundrum for people, because you had these slimmed down but very broad objects clauses with the incidental powers. But if you were acting for a bank and you were looking at taking security over a Guernsey company with these very broad powers, which may not have been specific around the ability to borrow, to grant security or permit any, or grant security not only over its own assets, but also in relation to other other entities, then so when I say that, I mean a Guernsey company that may be giving a guarantee, for example, in connection with a sister company, because you've got a group structure. There was a moment when people got a bit nervous, and then they started saying, well, actually, if we as bank want to get comfortable with this and advise our bank that they're fine to take the security, or for this company to give the guarantee, that the objects clauses were changed to beef them up, to be more specific, and put a provision in that quite specifically said, you can borrow, you can grant security, etc. And you can also do that in the context of of other companies as well, thinking about your group structure and everybody cross guaranteeing and whatever. Yeah. So that was an area that did get people a little bit nervous, and then we moved into the change that came about in 2000.
Do you probably expect post-2008 companies to just fall in with the default position?
Absolutely.
Or perhaps certain SPVs or JVs may still seek to limit?
Yes, yeah.
Okay, so that's your default position, because Caroline said, hugely important to look back to check, well, what does the memo of this particular company on which I'm advising actually provide? For those companies which do then still have or retain restricted objects, Section 114 sets out the Guernsey equivalent of the UK's saving provision, pretty much word for word. The validity of an act done by a company shall not be called into question on the ground of lack of capacity. It will not be challenged, will not be questioned by reason of anything contained in or omitted from the Constitution, the memo of the arts, any resolution of the members, or any agreement between the members, so a shareholders' agreement. The application then of that is really quite broad. The fact that the company has entered into some transaction which may in some way ought to be limited by something within the memo, the arts, a resolution of the members, or a shareholders' agreement, it cannot be challenged, it cannot be called into question, it cannot be invalidated simply based on the fact that it's alleged the company didn't have capacity because of some limitation within those various parts of the company's constitution. It's that then that serves to protect the third party transacting with the company. The transaction remains valid because it cannot be called into question on the grounds of lack of capacity. It remains valid, it remains enforceable. And so John Beaufort had the creditors had the benefit of the 2008 law here, or the equivalent in the UK laws. They would have been entitled to prove in the liquidation in the usual way. Their contracts with the company couldn't have been challenged. They couldn't have been, their validity could not have been questioned simply by virtue of the fact that there was a restriction in the objects of the company. But just bear in mind, as I said, that the application is wider. It goes beyond the objects in the memo to the articles, to any resolution, and also to shareholders' agreements. Section 114 then is looking to the capacity of the company. It's looking to the power of the company to enter into certain transactions, which is slightly distinct from what the indoor management rule deals with, which is the power of a certain individual, or the authority granted to a certain individual within the company to cause it to enter into some transaction. A particular director may have certain delegated powers within the company. Internally, that director may be entitled to do certain things. The question again, which the courts have been presented with, and which manifests in two different ways, but just following this train of thought. The question the courts have been presented with was, well, if someone is purporting to act on behalf of a company, they cause it to enter into some transaction, and it transpires that that person didn't have the authority to bind the company in the way that it did. What's the impact of that for the third party? That's one issue that the indoor management rule deals with. The other is where, as in Turkland, you've got an internal process that needs to be followed in order for somebody or for the company perhaps to have its authority to enter into a certain transaction. And again, the question before the court was, well, what if that internal procedure is not followed, and yet nevertheless the company is caused to contract with a third party? If the internal procedure hasn't been followed, does the contract still stand? Turkland then dealt with those two issues, and I mean, this is 1856. Bearing in mind the amount of difficulty that the objects clause and the capacity of the company presented over the years, Turkland 1856 deals quite neatly with the issues I've just described, looking to the authority of an individual or internal processes to be followed. And the bottom line in Turkland was, well, the third party can't be expected to have knowledge of whether or not some internal procedure or authority is being complied with. The distinction being that the matter that I referred to earlier, as far as the objects clause are concerned, would be clearly set out in a publicly available document, hence the application of the doctrine of constructive notice. You could look to the registrar of companies, obtain a copy of the memo, look at the objects clause, and see the restriction. However, when it comes to internal matters within a company, the authority delegated to an individual, or whether or not a particular procedure is being followed, that information is not publicly available, doesn't exist in the public domain, and hence the doctrine of constructive notice that the courts have in Turkland would not apply. The one point that the court did acknowledge was that the third party here, a bank, may be on notice of the fact that, as Caroline was discussing, perhaps there's a need for a resolution to be passed in order for the company to borrow a certain sum of money. However, it may not necessarily be the case that the outcome of that resolution is publicly available. And so on that basis, the bottom line in Turkland was that a third party is entitled to assume that all internal rules have been complied with. Is that then, which we refer to as the indoor management rule, the third party can't be expected to have knowledge of whether or not certain internal authorities, procedures, rules, etc. have been complied with. And so that carries through, again, into a saving provision here in 115 of the 2008. A little bit lengthier than the section 114 saving provision. It carries on to the next slide. But subsection 1, in favour of a person dealing with a company in good faith, so third party dealing in good faith, the powers of the directors to bind the company or authorise others to do so are deemed to be free of limitation. And that's limitation set out again in the same document as under section 114, memo or arts, a resolution, or a shareholders' agreement. There is obviously the caveat here as to the party dealing in good faith. And we touched very briefly upon that, I think. I can't remember why, but in the last study of Gary. Where you see here the extension of the saving provision under 115 in subsection 2, and I don't know why I put B there, I didn't need to. Looking to the third party and looking to the fact that they must be dealing in good faith, a number of additional points. They're not bound to make any inquiries to any limitation on the power of the directors or any person authorised by the directors. So there's no obligation on the third party to undertake any due diligence. They're presumed to have acted in good faith. That's taken as the starting point, and so the burden would be on the company to rebut the presumption. And the kicker under subsection C, the third party is not to be regarded as having acted in bad faith solely because he knows that a particular act exceeded the powers of the directors. There would need to be something more to demonstrate bad faith, an intention, I suppose, to take advantage of the company or the transaction in some way which demonstrated bad faith. However, to my knowledge, there's no judgments in England and Wales that look to interpret what that means and the circumstances in which somebody would fall foul of that. Because it would take a fairly brave person, I think, to test it, because that is a fairly broad blanket protection for the third party. Section 115, subsection 3 is what under this saving provision then brings the matter internally, because it's subsection 3, which provides that the fact that the transaction may remain binding, it may remain valid, the fact that the third party isn't challenged under subsection 2 doesn't mean that the directors themselves can't still be subject to a civil liability, I suppose. So 115 subsection 3 retains or makes clear that the directors themselves don't avoid liability here. If the company suffers loss, a claim could still be brought against the directors by the company or by way of a derivative claim to recover the losses that the company suffered as a consequence of entering into the relevant transaction. But taking all of that together, the transaction with the third party remains valid. It remains binding, it remains enforceable. And the losses then, or any losses suffered by the company, fall on the directors under subsection 3. And the company can decide whether or not to pursue that as a claim in the usual way, or for it to be pursued by the derivative claim. .114 though and 115, they're equivalents in England and Wales. There just is no real body of case law dealing with them because they are such straightforward, I think, blanket provisions that protect the third parties. And the way that the only time I've ever been exposed to issues that you would otherwise say fall within those provisions are in circumstances where we're advising minority shareholders again in respect of claims against directors. And that's the only situation I've ever encountered it, is looking at it from that internal point of view. Is, well, what can we do to recover the losses suffered by the company as part of generally a wider framework of issues between the parties. But I've never been faced with a simple question of whether or not the third party transaction is valid. I think that's just taken as granted now. Any other thoughts, Caroline?
No, pretty much. No, I don't think there are. I mean, it's just more about what had happened historically. But now I'm not aware of any case law there's being challenged. It is accepted that this is position.
Yeah.
And then you I think it's right. That the issue then becomes very much in a practical sense looking at, hang on, what's gone wrong, the internal procedures, processes, risk of liability for the directors.
Yeah.
Worth discussing what these common internal procedures might be. What might we see nowadays in terms of what directors might have to comply with to make sure that.
I mean, looking back to Turquand, it was about borrowing money. and the internal procedures that need to be followed in order to borrow money above a certain level. Caroline will no doubt confirm, but certainly in England and Wales, you'd expect, and the position under the statute, certain types of transactions that you have to have shareholder approval. But it's common to actually make that even tighter, so that even for certain specific levels of borrowing, you've got to have shareholder approval, you've got to follow that internal process. Now, one of the reasons why you haven't got this huge body of case law is, again, go back to the points Caroline made, is that the banks are hot on this, and the banks will want to see the resolution.
Yeah, I think that's right. And so if you've got the point where you may have in your articles, you can only borrow a certain amount, certain up to particular percentage, etc. I mean, obviously, you have to, the directors have to be taking that into consideration. Another area where directors will possibly want to think about this is just this general rule. We're slightly going off track, but I can see where you could get directors have to think about what they're doing. But if there's a discussion around a transaction and what is the commercial benefit to a company, the directors may well go, no, we understand the transaction, they're guaranteeing something. We understand this transaction, we understand we're part of a bigger group. If we don't provide this guarantee because parent is receiving this funding, then clearly that makes it difficult for the group as a whole, but also for the and that then has potentially have an adverse impact on the company itself. So the directors themselves may be able to get themselves comfortable with the reason they're doing that when they're looking just solely at the company. But if you're acting for a bank may well say, well, that's all very well, but we go that step further because we want to know that actually you directors really do have that authority to do it. And one of the ways that you can prove that, particularly if there are any concerns around solvency of that specific company, would be to seek a shareholder resolution which backs it up. So that shareholder resolution may not necessarily come because the directors themselves think they need it, although if you're advising directors in that situation, you may well go, if I were you, I would get that shareholder resolution. But you may also find the banks and the Banks Council saying, we want to know you company and you board have that authority, so we also want the shareholder resolution that says there is commercial benefit around this and this is in the best interest of the company. So that is a very common situation where you're looking, it's not specific internal rules as such, that's more the general powers of the directors and the fiduciary duties. But you will also find other procedural things. I mean, you can have shareholder agreements that reserve matters. There'll be things there, and the directors will be thinking, oh, hang on a minute, we need to think about getting an appropriate consent or whatever in order to be able to move forward with what we're being asked to do. And also, as you say, there may well be procedures and processes, policies and procedures. Everybody's much hotter on that kind of stuff.
When there's certain signatories, signatories, things like that.
Absolutely.
Certain directors to sign off on certain value deals and things like that.
Absolutely. Yeah, trust companies particularly, in that very practical scenario. Yeah, those are exactly the kind of things. Yeah.
But again, it comes back to a more commercial point, which is actually the third party will want to see the signed document. Okay, so that's the whole, again, very, very quickly, and I am aware of how fast I'm talking, with corporate capacity. Which ties in then with the constitution of the company generally. Now, those issues go into corporate capacity. As I said, if you were faced with that in practice or in the context of a problem question in the exam, the answer is really straightforward. As I said from the outset, the third party is going to be protected. The transaction will stand unless you can prove bad faith under 115. But again, I think that although there is that caveat, the circumstances in which it can be proven are extremely limited, and I've never seen an example. It wouldn't then be the case that you would be expected to go through an exploration of the history and the development of these principles, because that is the law. And we're not really interested in what happened in Turkland or in John Beaufort or any of the other cases. As I said, I could go through certainly tens of cases that evidence the problems that were faced by the courts during the 20th century. But there's just no need for you to get into the background of that. And so again, if this was to come up as an issue, as with something like wrongful trading, which we discussed yesterday, it would just be kind of a bolt-on within a set of facts that you would touch on fairly briefly, demonstrating your knowledge of the saving provision either under 114 or 115, setting out what it is, applying the relevant test, and then just giving the outcome based on the facts. If that was tied into a question on directors' duties, then that would be your link through potentially to exploring other breaches of duty by the particular director. This may simply be one issue within a wider set of behaviours that can be brought into question by whoever your client is. Perhaps you're advising a shareholder, perhaps you're advising the company, perhaps you're advising the director himself. It could just be a part of that package of issues. One which should be relatively obvious on the fact, because the signpost is that the company's entered into some contract with a third party, and either the company had restricted objects, which is an obvious red flag, or the particular director wasn't authorised, or he didn't follow a particular procedure, he didn't obtain a particular resolution, etc. Which again will be a fairly obvious red flag on a set of facts that stands out and will make you think, right, I need to go to the saving provisions and apply those. You know the answer, but you need to show you're working out. As I said before, we need to work through what the relevant provisions are. It's not enough to just say transaction will be valid, third parties protected, it's an internal issue. You need to just briefly explore the provisions within the law itself, but don't go so far as to bring in an academic discussion of the history and the developments over the years. And I try to limit the discussion of that in the study guide, because again, it's just irrelevant these days, frankly. But it is quite interesting when you look at some of the cases and think, what on earth was the court doing? Because they are obscene, frankly, the outcomes in some of those cases. Okay, good. Any other questions on that then, before we move on? Keeping then with the theme of the constitution of the company, what makes up the constitution of the company? We've talked about, and the four of you are well aware of, the core constitutional documents. We have the memo of incorporation, we have the articles of incorporation. May very well call them an association by mistake. Used to saying. But here we have memo of incorporation, articles of incorporation. And bear in mind that generally any resolutions of members will also be caught up in what the constitution of the company is. I can't remember off the top of my head whether or not there's a defining provision in the Guernsey law. There is in the UK in the Jersey law, which defines the constitution as including memo, arts, and resolution of shareholders. I can't remember if you have the same defining provision here. But that is generally what you'd expect the law to treat the constitution as. The saving provision is slightly different, because as we saw, they incorporated shareholder agreements, which are generally excluded from the definition of constitution. But my rule of thumb is that if you see a reference to the constitution within the law, it's a reference not only to the memo and art, but also to any resolutions passed by the members from time to time.
Memorandum may be in the French language.
Sorry?
The memorandum may be
Yes.
in Never say that. Yeah.
Yeah, it is. Yeah.
Even the one recently, David, is set up completely French. Anyway,
Yeah.
French name. I didn't do it, but we had a French name, French constitution.
Oh wow.
Didn't try and read it.
It does say it's lawfully amended from time to time.
Right, so lawfully amended from time to time, yeah,
Yeah,
incorporated
and says
then
that for the memorandum.
resolutions
Yeah.
Of the members, I
Yeah.
would say, excluding shareholders' agreements to be misled by what
Yeah.
one and five say.
Yeah.
The memo then, historically treated as the most important document in the company's constitution because it contained all important object stores which said what the company was decided to do. But over the years, the importance of the memorandum has very much diminished, and certainly in the UK now, post-2006, it's a single piece of paper that has the names of the initial subscribers on it. That's all it generally tends to be, with nothing, with no further provision within it. I haven't seen a bespoke memo for a very, very long time. Because generally now incorporations are obviously done online, and in doing so it generates a pro forma memorandum, single page with the initial signature on. It's as simple as that. Obviously the law though sets out a bit more of a flowery definition. So it's a memorandum stating that the founder member wishes to incorporate a company, and subsections 2 through 5 then set out various matters which need to be covered off within the memo itself, which I'm not going to go through because you're probably familiar with them yourselves. It's subsection 6, which for the reasons we've just been discussing is probably one of the more important points. If the company is to have restricted objects, then they need to be stated in the memorandum. And under subsection 7, the memo can make provision for any other matter not included within those core requirements concerning the company, its members or officers. So in theory, you could build rules, constitutional rules, into the memorandum, albeit that would normally be reserved for the articles. But in theory, you could incorporate what you like into the memo, and you could take constitutional rules from the articles and place them in the memo. Is that something you like this in Guernsey practice?
The where I've seen 15.7 used is if you look at the, and sorry because I haven't prepped this bit, but if you look at how you amend a set of your memorandum, it's quite specific at about what you can do and the bits that you can change. So what we've done in practice is, as part of 15.7, include something that says if there's anything else in your memorandum that you want to change, you can do it by either unanimous, a special, typically a special. You could try for an ordinary as well, resolution. So what you've done there is given yourself the flexibility to amend other provisions in the memorandum, because I think, and I'd have to have a quick look, but when you look at how you alter your memorandum, it's quite specific at how you do it. So that's where it's used.
Yeah. So to overcome the issues that then ultimately come with the issue of the Constitution,
Yes.
at the moment.
Yeah.
But I mean, from my point of view, you just don't see that in England and Wales. The memo is just a load of signatures. That's all it's been reduced to. Far more important though, the articles. So the articles of incorporation are rule book for the company, and really the true constitution these days, if you like, because it's in the articles that you'll find the bulk of the detail as to how the company is intended to be run. Not looking to issues of day-to-day management necessarily, but in terms of its corporate structure and its internal mechanisms of governance, you'd expect those to be set out in the articles. And so section 16, subsection 1, every company shall have articles of incorporation which set out regulations for the conduct of the company. There's no limitations on what the articles could contain. They could contain quite odd, peculiar provisions specific to that company. But generally, they will, I imagine, follow the standard articles which exist under the 2015 regs. you'll be provided with the standard articles in the exam. And so in the event that you're looking to an issue concerning governance within a company, if you're not told explicitly, then you're safe to assume that the standard articles will apply, and you look to those within the regs themselves. And there's, over various topics, I'll highlight some of the relevant provisions, but you'll have the benefit of those available in the exam. I think, yeah, I should say, but no, you only have to. Same as you're going to have the 2008 law, so they're both going to have to be there.
And then the standard going to be
Yeah, there will be.
just because those are like kind of terrible. But as in like, you know, the first thing practitioners do is like every firm has their own.
Yeah.
So
Yeah, for obvious reasons, for purposes of an assessment.
I'm just
but that's interesting because again, usual, certainly England Wales practice is you're incorporating a company online and you just tick the tick box that says that you adopt the model articles. Yeah.
Would
certainly-
you add to them rather than actually take things out, or is it
just replace them.
Yeah, particularly within finance, I suppose, within funds when you're looking at
Yeah,
JVs,
yeah,
SPVs,
yeah.
it's a whole different from that point of view. Any other thoughts just about the articles generally and their content?
No, except that they're just because of this point that it's a different practice to obviously what happens in the UK. That point about disapplying your standard articles, make sure that's in there, because that can be a little bit of a that can trick you.
That's subsection 3 here.
Yeah.
Variation or disapplication of the standard articles must be set out in the company's articles, like presumably your firm's model articles, one of the defining provisions.
Yeah.
Okay, so we can't really go into a huge amount of detail about what the articles contain. I don't do it in the other jurisdictions because, again, you just sit down and read them and they're not particularly interesting. I was wondering if any of this is particularly interesting. But as we work through various topics where there's relevant provisions in the standard articles, I'll back those up. But nevertheless, we'll have a copy in the exam. What do they do? What's their effect? What's their impact? Well, 20 subsection 3 recognises that the Memo and Arts form a contracted membership. They are the contract on which the relationship between a company and its members and the members themselves are based. It's treated, it's recognised as equivalent to any other form of contract in effect. However, it needs to be subject to a couple of oddities, I suppose, if you're looking at it purely from a contractual point of view, to recognise the fact that over time, the makeup of the beneficial owners of a company will change. People will join, people will leave, so on and so forth. If you were taking a purely contractual view of that relationship, each time somebody left or joined, you would need to re-execute the contract. Someone coming into the company would need to execute a copy of that contract of membership, confirm their acceptance of its terms. In 90% of the companies of the UK, that's not an issue, but for those which make up publicly traded companies, of course, it just isn't even something that's imaginable or possible in practice. And so necessarily, the contract of membership as it's defined in the company's law across various jurisdictions is the same, which is you have the Memo and Arts, and they are deemed to be comprised in agreement duly executed by the company and each member, and contain covenants on the part of the company and each member to observe all provisions thereof. It's simply treated as the odd contract which, upon acquiring a share, upon taking membership of the company, you automatically become subject to without having to formally sign off on a fresh version of that contract for execution. And it's one of the, I'm not sure if it's the only, but it's one of the very few circumstances in which that happens in law, that the parties to a contract become subject to it, notwithstanding that they haven't formally executed it or entered into it. They become subject to its terms simply by virtue of the legislative provisions. So it's that which enables, as I said in the UK, public trading of shares. You can buy shares, you can sell shares within minutes of one another, and during that time that you hold the share under the equivalent position in the law, you're bound by the constitution of that company, notwithstanding that you've never sat down and actually executed it or even taken actual knowledge of it. So that's the reason why 20 subsection 3 is drafted in that way. It simply creates this binding contract. And that recognises one of the, again, kind of founding principles of company law from Hickman and Kent, which considered the nature of that contract of membership and, in that case, the actual impact of the articles. The contract of membership here under 20 subsection 3 deals with the bellow and the arts. In Hickman, the court was focusing on the articles themselves and what they represented and what their effect was. And it held, quite simply, that the articles bound the company to the members and vice versa, and bound the members as members, so as between themselves, meaning that there was an enforceable contract. The company could enforce that contract, it could enforce the articles against its members, the members, of course, could enforce against the company. And a couple of other practical points stem from that, which are less relevant these days, but the court determined then that the articles couldn't bind a third party, it only existed in the bubble between company and members as between members. And that the court laid the groundwork for what ultimately developed into derivative claims and the nature of the rights bestowed by the articles upon the company and upon the members, and how those were enforceable. Certain rights are personal to a member, certain rights are not. And we'll explore that a bit more when we look at minority protection and the protection of members generally. But in Hickman, they laid that groundwork, recognising that certain rights were personal to an individual, and that individual could sue on the basis of a breach of the articles to enforce that right. But in Hickman, the court didn't develop further the idea of what was a personal right, what was not. That didn't come until much later. But it laid the groundwork for then the possibility of derivative claims. So claims being brought by a member to enforce some right of the company, to protect the company. Again, you could read huge volumes of articles over Hickman and the decision in Hickman, but the fact is, we've got 20 subsection 3. It explains the effect of the articles in the memo. It's this contract of membership. It doesn't matter that someone hasn't formally executed or entered into that contract in the usual way. They are still bound by it. That means they're bound to the company is bound to them, and the members are bound to one another. And as we'll come on to see in a bit more of a practical sense this afternoon, that means the possibility of claims then being brought for breach of those articles and contractual provisions, if you like. The common practice, though, is that we often find parties entering into shareholder agreements which may make provision that extends beyond what's contained within the articles or memorandum. And so you may see a shareholder agreement that's purely entered into as between shareholders, or you may see an agreement to which the company is also a party. It's that which has given rise to some difficulties over the years as to how the company, which is subject to its own constitution and which is subject to the law, can then seek to enter into some side agreement with certain shareholders. And so the general point to take away on that is that it's actually quite difficult to enforce the terms of a shareholders agreement as far as a company is concerned. But as the court recognised and put it that, as between the other parties to the shareholders agreement, it's a contract like any other, and they can enforce its terms as against one another. So the courts have generally been satisfied that as between shareholders, the terms of an agreement are enforceable, and for the fact it's a contract like any other. It's when you introduce the company as a party that there have been difficulties. In Punt, for example, the shareholders agreement sought to make provision that the company couldn't alter its articles, notwithstanding that that's a legislative right, or it is now. I don't know if it was in 1903, but it's a legislative right now. And provision will generally be made in the articles as well for alteration. And in Punt and Simmons, the court recognised that a company couldn't contract out of its right to alter its articles through a shareholders agreement.
How do you deal with the situation in nominee arrangements?
Mm-hmm.
So, would the nominee company is actually listed on the register, either by entry into the shareholder agreement, or is it the ultimate beneficial owner? For example, if that nominee holds the shares by a declaration of trust for somebody else, and who then enforces the right? Because say this nominee may hold shares for a number of people.
Yeah.
Their trust.
Usually the economic owner, so it will be the beneficial owner, and then often you'd have direction within the shareholders agreement. So it's the beneficial owner. It's either acts by itself or as by its nominee. So there'll be typically language around that where it can either do it itself or direct someone to do it for it. Yeah. Because you are always typically in that situation looking at where's the economic interest lie, who's got the power, who's then going to control that economic interest, how do they control it?
Mm-hmm.
That's typically what you see.
Is that something you see regularly?
Yeah,
Right, okay.
yeah, we would.
Well, because when we talk about enforcement, so say shareholders agreement, normally if you hold 5 shares, I hold 95 wins in shareholders agreement. But what if you are not entered on the register as the shareholder because you've appointed Racial Nominee Limited to hold your shares on their trust for you? Does Racial Nominee Limited enter into the shareholders agreement with me or do you? And how does it have an impact on enforceability?
Oh, I see.
You know what I mean? So if we only dispute on the shareholders agreement, do you bring the action or does Racial Nominee during the point? Yeah, that was just my.
So Lauren would be the named party, but in theory it could be executed by
Yeah.
nominees limited.
Yeah.
That's all the relevance, isn't it, to that relationship?
Yes, it could, and then you could always have your nominees if you wanted to. I mean, because all they'd then be doing is everybody who might be involved in it would then know about it. Typically, you just have the beneficial owners involved, and then obviously if it's a shareholder dispute, you've got, because you contracted as beneficial owners, that's obviously where you'd be having your fight. There's a breach of contract. If you then, I guess, if you had to kind of implement some of that, and that's where your shareholders come in, then you're directing your shareholders to do X, Y, and Z and pursue your claim for you that way. So yeah, it gets it could get a bit messy. Yeah, no, but if you're thinking about 50-50, 50-50. Yeah.
As a rational counterparty, they will have the ultimate beneficial counterparty. It's a contract. It would be useless having a nominee. It's just
The nominees just
the nominees,
administrative type function.
It would be a sort of frustrated
But would the nominees also need to be in order to be bound by any direction?
I don't think, I'm just trying to think back, and I don't think you necessarily have your nominees involved, because you'd always have in place, as between beneficial owner and legal holder, there, those arrangements and how that legal owner is directed to do what it has to do. You could, though, and there's nothing to say you couldn't, but if you think about who may be a legal owner, they may not want to be party to that contract, because you're typically talking about your trust companies and their nominee entities and stuff like that. And they just may not want to get into that type of arrangement, unless all it is they're just acknowledging that the thing exists, so that they know they, have to abide by it, type of thing. But you can deal with that in different ways.
No, that's an interesting point. It's not something I've ever seen in practice in the UK. It's not that common, but obviously necessarily it is. So it's an interesting point, but I think you've just got to bear in mind that the nominee is, for all intents and purposes, doing what they're told, and this isn't quite right, but they're effectively acting as an agent. In reality, they're doing as they're told.
I just wondering, because the economic economic interest is not actually the shareholder. I understand, of course, beneficially they are.
Yeah.
But on the register, as far as the company is concerned, the nominee is the shareholder. And that's why I was just wondering.
And if you think about it, then if you look at people who hold shares in a listed company, oftentimes they'll be holding it through a nominee. And then you're absolutely right to be thinking about that, because of course when you then need your, what we would call your investor, not your legal title holder, you need them to make a decision, then you've got a whole process going on in the background where your information has to flow down to your beneficial owner so they can make the decision. They then have to give instructions, and that's how the instructions are then executed. So you're right, I mean, it's in this circumstance, but it could also be, in your publicly traded shares.
Good, okay. So the only other point then off here, Russell and Northern Bank. So following this idea of, well, what can a company actually agree to in the confines of a shareholders agreement? Hunt & Simmons said it couldn't contract out the right to alter its articles. That existed as a legislative right. It exists within the articles themselves. In Russell and Northern Bank, the court took it slightly further, though ultimately followed the same outcome. In Russell, the shareholders agreement provided that the company wouldn't increase its share capital. Now again, that exists as a legislative right, and it exists as a power within the Articles of Association. So the shareholders agreement provided the company wouldn't increase its share capital without a unanimous consent of the parties to the shareholders agreement. Nevertheless, the company did it did seek to increase its share capital without obtaining unanimous consent. And I think one of the parties to the shareholders agreement took issue with that. And the court said that the company couldn't fetter its legislative right to increase its share capital. It couldn't contract out of what is a legislative right. There's another point on that I'll come back to in a moment. And on that basis, held that the increase was valid, and the shareholders agreement remained enforceable in all other respects, save with regards to that one provision. So that was how they extended it slightly beyond punt. In Russell, the remaining provisions within the shareholders agreement remain valid, and it's simply the clause, the provision which seeks to in some way fetter or limit the rights of the company that enjoys under statute or within the articles. It's only that which is now void. The increase of share capital as a legislative power is an interesting one because it's subject to any provision within the Articles of Association. But in Russell, there was no caveat, there was no carve-out, there was no limitation within the articles themselves. The only limitation was in the shareholders agreement, and that, of course, that could not be relied on by any party to in any way fetter or limit what is a legislative right of the company. But that balance of the shareholders' agreement remained valid and enforceable. It also went one step further, which is that with that in mind, it was only the impact of that clause on the company that the court were bothered by, and in fact said that when the company's resolution was placed before the members to increase its share capital, anyone who was a party to that shareholders' agreement would have to vote in the spirit of what the relevant term provided. So the term within the shareholders' agreement was not to increase share capital. The company couldn't be bound by that, and so it could still propose a resolution to increase its share capital. But when that resolution was presented to the members, those members who were parties to the shareholders' agreement, the court said, would have to vote on that resolution in line with the spirit of the shareholders' agreement, which in that case would be not to increase the company's share capital. So they'd be voting against the resolution. Anyone who was a party to that agreement and who sought to vote in favour could have been enjoined from doing so by the court. And again, it's quite an important judgment, again, one of the few that I've bothered to read through over the years, but it's quite interesting, all the various issues that it brings in. Company's not bound, it can't be compelled to fetter a legislative right or one which exists within its constitution, number one. Number two, any such clause which purports to have that effect will be invalid, but the balance of the agreement will stand as a whole, it will remain enforceable. But that's only insofar as the company is concerned. Point number three is it remains enforceable as between the members themselves. And in fact, then the court will require them to vote in the spirit of whatever was agreed in the agreement, which I'm not sure I feel about that. I thought it was slightly odd view taken by the court, but that's the decision they made.
What was the? It does sound like this was really. What was the logic of not having discretion? Because logically, it should be able to.
I don't think there's no logic specific to the facts of that case. It's the general policy that if a company has a legislative power, legislative right, or one which exists within its constitution, it can't be compelled to contract out of it. And that's a matter of policy. It gives certainty, I suppose.
But then at the end, the people with economic interest in that entity, they can agree what they want.
Yeah.
And if they don't, if they don't abide by that, that's where the breach of contract will come in, and where you have the issues. But I think it is probably policy, isn't it?
It's ultimately safeguarding the interests of the company as a legal person.
Yeah.
Which is hugely academic.
I see it the other way though. I think where I'm going with it is that I can understand the logic to say, let's say the company had the power to increase its share capital in its articles.
Mm-hmm.
I can understand that the court said you can't, by say, a director's resolution, resolve that it's in the best interest of the company to enter into a contract where you have better discretion, because you'd be amending the articles by the fact if you went down. I can understand that, but in principle, a company should be able to fetter its. I mean, I see it way, at least in the first place, it should be able to fetter its discretion if it had, like, say, I don't know, a unanimous resolution of the share.
Yeah, okay.
That's kind of how.
But this is the exact problem, isn't it? Is that you're then starting to talk in ifs and buts.
Yeah.
If this, then that. But if this, then that. The problem is you've got to have a line somewhere.
Yeah.
And that's it.
And it just gets.
It's a general safeguard, because how often will you get unanimous consent?
Yeah.
Maybe over here you get it all the time, but certainly we tend not to see it regularly. So you've got to have a line, and this is the line. If they have a legislative right, a legislative power, they're entitled to exercise it. Because there are then further mechanisms. As Caroline said, you can either have the beneficial owners themselves entering into some agreement that's personal to them, or you just simply look to the fact that the type of provisions we're talking about here have internal procedures that need to be followed anyway. It's not as though the company can simply say at board level, we're going to encourage. Generally, there's some further protections built in. There's got to be a resolution at board level. There's got to be a resolution at members level. And that's then where you see further safeguarding, but drawing a balance with the flexibility that you're talking about. The company can be compelled to do something through majority rule. But there's got to be a line.
I guess the line is the court. Is the court in essence just saying, just keep it in the articles?
Yeah, the court's there, but the general policy of the courts is we're not interested in the management of the company. We're not going to get involved in it. If it's a commercial matter for the company, deal with it. And that's, we'll come on to discuss that a bit more in a couple of topics, but that's why there have been some decisions with regards to directors' duties and minority protection that actually, on the face of it, are probably not quite right, are probably a bit unfair. But the court is saying, we're not interested. It's a commercial matter. We can't be expected to have the expertise, the knowledge to know how a particular company should be run or what ought to happen internally, which is a bit of a cop-out, but that's the view that they take. What did you want to say, Jasmine?
Yeah, couldn't be very important.
But it also, I mean, it's that slightly off point, but it's still where we're talking about articles and shareholders' agreement. And there's always this debate about how much do you put into your articles and how much would you put into a shareholders' agreement. And if you think about what we've been talking about, what happens where there's a breach of contract between your shareholders with regards with the economic interests. Well, you know, let them fight out whatever they want to have, fight back. But when you're trying to run your company, you've got directors who've got their fiduciary duties and they've got to comply with the constitution of the company. You know, it's going to make it a very difficult job for them if they've got such a restrictive constitution that, you know, you're constantly going out to shareholders because you need, if you want to buy something that's above £5,000, you've got to go and get a shareholders agreement. Stick all of that in your shareholders agreement. Let the directors run their business. They'll be aware that there'll be these restrictions around it. But obviously, what you're I think giving you a little bit more flexibility to your company to be able to run, and then you have some of the I suppose the detail in the shareholders agreement, because what you typically don't want to happen is something in your articles which, if it's breached, that becomes a real issue, because you know you're talking about territory where the thing could be void, whereas in your shareholders agreement you're thinking more about on the commercial level. You know, if they're going to have a fight because there's a breach, then let them have that fight away from the company. I think that's how we tend to look at it when we're talking around shareholders arrangements, that there are certain things you just wouldn't necessarily want to put into the company's constitution because you wouldn't want to trip up the kind of day-to-day activities of the company.
Yeah, and it's that really which then, looking at it from my point of view and an assessment, shareholder agreements are quite a useful thing to build into a fact scenario, because the actual issues going to, well, as we saw on the first set of slides, dealing with the two saving provisions, those are very quick, short answers. Whereas something like an issue going to the impact of a shareholder agreement and the contents of that and some particular term on the company, number one, and then as between the members themselves, number two, that's a good half-page worth of discussion that's getting you to look to the nature of the constitution, the kind of introductory point on the previous slide with regards to the nature of that contract under section 20 subsection 3, and its interplay then with a side agreement, a shareholder agreement. That in itself could test you on two different levels. It could be that the company is a party, it could be the company is not a party, it could be that you're simply not told. Those in themselves have different outcomes depending on what the true scenario is. If the company is a party, you've got to look to the extent to which, well, what is the impact of the relevant clause that you're being asked to assess? Can the company actually, is it likely to be able to be bound by that provision? Certainly, if it's something that goes to fettering a legislative right or some power that exists within its articles, then the likelihood is the company won't be bound and can in fact act entirely contrary to whatever that provision may be. The next limit of your analysis is, well, actually, notwithstanding that, according to Russell, the members themselves, the parties to the shareholders agreement, they remain bound, and they must act in accordance with the spirit of that agreement. That means voting on any resolution that is proposed. That means voting in accordance with the spirit of whatever that provision provided. Now, this is a point Jasmine made yesterday, which is, do you need to read 150 High Court decisions to kind of be able to identify the fact that a fact pattern ties into a particular case? And it's probably one example here on Russell where I tend to keep it fairly close to Russell itself, because you need that clear steer to be able to make the call that the relevant provision is likely to be held unenforceable insofar as the company is concerned. The scope for what that relevant provision could be is enormous. It could cover any aspect of the internal workings of a company, and so hence I tend to tie it, those report to Russell. Not precisely, but dealing with similar issues, going to share capital or something. Okay, any other questions then? The next few slides deal with alterations of the memo and the articles. I was going to my intent was to press on until 1:45, but actually that's a neat little section in itself, and it's going to take longer than 15 minutes to go through. So I think let's pause and have a break now for 10 minutes, and then we can pick up with that as quite a neat little topic, I suppose, within the topic. Once you have a coffee. Okay.